All right, let's go ahead and get started here. So good afternoon, everyone, and welcome to this webinar training titled Sentencing Guidelines in MAGS 101, the Circuit Court State's Attorney, Parole and Probation, and Defense Attorney Orientation. My name is Catherine Pembroke. I am the Administrative and Training Coordinator for the Maryland State Commission on Criminal Sentencing Policy, commonly referred to as the MSCCSP for short. The sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. Accordingly, your participation in this training and staying up to date on sentencing guidelines is important because it helps to promote the consistent application of the guidelines. So we really do appreciate all of you taking time this afternoon to attend this training. Please note that today's webinar is being recorded, and either this video or a similar webinar video will be made available on our website. Now, before we get started, I just want to go over some general webinar housekeeping. I know we're all familiar with Zoom at this point, but I do want to point out that we are asking participants to remain muted throughout the course of the presentation. That's just to ensure that we get through it in a timely manner. But that said, we do want this to be an interactive webinar. So please feel free to submit any questions, comments through the chat box here. I have my colleagues, Sarah Bowles and Kathy San, are attending this webinar this afternoon. And they will be able to respond to any questions that you may have. Now, we do encourage participants to submit their questions to the entire group just so everyone can benefit from seeing the question as well as the answer. That said, if you don't feel comfortable doing that, that's fine. If you could just send a message directly to Sarah Bowles with your question, she will be able to respond to you directly then. Also through the chat box, you'll see a PDF of today's presentation. Feel free to download that to your computer or just save it for future reference. All right, so let's move forward to the agenda for today's training. I know many of you are probably somewhat familiar with the guidelines themselves at this point, but I know that we do have a couple new practitioners who are attending today's training. So I thought it'd be helpful to start the presentation by providing some background information about the purpose and goals of the Sentencing Commission itself. And then we're going to get into the various sections of the guidelines worksheet and talk about how those should be calculated. We're also going to look at some special applications that adjust the calculation of the guidelines in certain scenarios. And then we're going to wrap up with a brief demonstration in the Maryland Automated Guideline System, which we commonly refer to as MAGS. And throughout the course of the presentation, we're going to focus on some recent and upcoming guidelines related updates. Okay, so let's begin with a brief history of the guidelines and the Sentencing Commission in Maryland. Now, Maryland was actually one of the first states to initiate a sentencing guideline system. The guidelines were first introduced by the judiciary. In April 1979, the Sentencing Guidelines Advisory Board, which was formed by the judiciary, approved a system of voluntary guidelines to be piloted in 4 jurisdictions. These sentencing guidelines were then approved for statewide use in the circuit courts starting in 1983. Now, the guidelines in Maryland were in effect statewide for about 15 years with oversight by the judiciary. And then in 1999, the legislature decided that a permanent independent sentencing commission should be created to have oversight over the guidelines. And thus, the Maryland State Commission on Criminal Sentencing Policy was born. Now, the enabling legislation that creates the current day Sentencing Commission outlines a statement of intent for the MSCCSP in Criminal Procedure Article Section 6-202 that includes 6 goals. First, that sentencing should be fair and proportional, and that sentencing policies should reduce any unwarranted disparity, including any racial disparity, and sentences for criminals who have committed similar crimes and have similar criminal histories. Second, that sentencing policies should help citizens to understand how long a criminal will be confined. Third, sentencing policies should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, that the sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be the confinement of violent and career criminals. And finally, that sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. Now, the Commission has a few primary responsibilities to help address these goals, with our primary responsibility being that we implement and maintain the state's voluntary sentencing guidelines. Now, this is accomplished through the second major responsibility, which includes the collection and maintenance of an extensive database, which is assembled via the data submitted on the sentencing guidelines worksheets. The commission uses the guidelines data to monitor circuit court sentencing practice, and it also examines sentencing patterns and reasons for departure for specific offense categories and within individual cell ranges to consider adopting changes to the guidelines when necessary. And finally, the commission is responsible for providing training to criminal justice practitioners to promote the consistent application and accurate completion of the sentencing guidelines worksheet. Now, the MSCCSP was created as a balance board of 19 members from all three branches of government. The commission is currently chaired by Judge Brian L. DiLeonardo from the Circuit Court for Carroll County. Membership also includes 3 additional judges, including representatives from each of the 2 trial courts and 1 appellate's court representative who serves as the chief judge's designee. The remaining 15 members include a cross-section of criminal justice officials from the other 2 branches of government, as well as 2 public representatives. Appointed members serve terms of 4 years, and they are eligible for reappointment. Now, the MSCCSP makes decisions with respect to the guidelines after deliberating with the many stakeholders that encompass our Maryland criminal justice system, most, if not all, of its constituencies being represented here on the commission. Now, let's get down to the basics here. So what is the purpose of sentencing guidelines? The sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote fair, consistent, and equitable sentencing practices, whereby offenders who are convicted of similar offenses and who have similar criminal histories, they're treated and sentenced alike. Now, the Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. The guidelines help achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. The guidelines account for the most common, but certainly not all, characteristics of an offender and his or her crime that are most relevant to the sentencing decision. And they help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. So let's discuss some of the basic principles of the guidelines here in Maryland. The first is that the sentencing guidelines in Maryland are voluntary, so judges may, at their discretion, depart from the guidelines. The voluntary nature of the guidelines emphasizes that they are designed to be a tool to help inform sentencing decisions, and they're intended to complement rather than replace the judicial decision-making process. They're also intended to be primarily descriptive. So in other words, the guidelines are informed by analysis of actual sentencing practices and are designed to illustrate to judges how their colleagues are sentencing on average for a typical case. The descriptive nature of the guidelines means that they are not intended to be static, but rather they are dynamic, and the guidelines may be amended when the data indicate that sentences are not consistent with the recommended ranges. And if we have practitioners here who may remember last year, July 1st of 2022, how we actually made changes and revised the sentencing matrices for drug and property offenses, many of those cells within the matrices were reduced or lowered to more accurately reflect how judges were sentencing in those particular cases. So I just mentioned that to kind of reiterate that it's important that we're getting as much data as possible, since it is that data that helps inform these sentencing policy decisions that we are making. And the final basic principle that I want to discuss is that the Maryland guidelines are generally limited to cases that are sentenced in the circuit court. So let's take a closer look at the scope of the sentencing guidelines. So I just mentioned that they apply to criminal cases prosecuted in a circuit court. So the sentencing matters that you see on the left-hand side here, these require a sentencing guidelines worksheet. And we refer to these as guidelines eligible sentencings. So those can be cases originating or circuit court original sentencings, rather, including adjudications of probation before judgment, jury trial prayers and appeals from the district court. They are guidelines eligible only if a pre-sentence investigation is ordered. Reconsiderations, modifications, and 3-judge panel reviews, They require a guidelines worksheet if the case involves an underlying crime of violence as defined under Criminal Law 14-101, and if there has been an adjustment made to the active sentence as a result of that modification. Now, there are two recent updates that I want to highlight with respect to these guidelines eligible scenarios. So you'll see here how I have the reconsiderations, modifications, and 3-judge panel review bullets highlighted in red here. So I just want to note that effective November 14th of 2022, the commission clarified the term reconsideration by adding the term modification, as we believed this would help bring further understanding as to the types of sentencing scenarios involving crimes of violence that require a guidelines worksheet. So this includes guidelines eligible reconsiderations and modifications. That includes sentence adjustments imposed pursuant to Maryland Rule 4-345, a Health General 8-507 order, or a 3-judge panel review. And to further clarify, also effective November 14th of 2022, the collection of worksheets for 3-judge panel reviews have also been limited to those involving crimes of violence as defined under Criminal Law 14-101. Now, this change provides consistency with the data collection protocol and reporting requirements for reconsiderations and modifications. Now, the sentencing matters that you see on the right-hand side here, these are handled by judges in a circuit court, but they are excluded from guidelines coverage. So those include jury trial prayers or appeals from the district court unless a pre-sentence investigation is ordered. If the offense carries no possibility of incarceration, violations of public local laws and municipal ordinances, sentencing hearings in response to a violation of probation, criminal non-support and criminal contempt cases, cases adjudicated in juvenile court, and then finally, district court sentencings are excluded from guidelines coverage. Now, I do want to point out that we've worked with GIAS to establish a guidelines eligible case indicator. Since the majority of jurisdictions are now using MDEC, I thought this would be a helpful tool to highlight during the course of this webinar here. So you can see here we have a screenshot for the criminal docket for Anne Arundel County dating back to January 24th of this year. And you can see that the guidelines eligible cases, they're marked with this MAGS yes indicator, indicating that a guidelines worksheet should be initiated for the case. So we've worked with GIS and really fine-tune this criteria. If you think that this would be a helpful tool for you, I know a lot of practitioners look to it in advance of sentencing, just to know which upcoming cases require a guidelines worksheet. Same with law clerks and administrative assistants. Look to this docket to know which cases they'll ultimately have to submit sentence information for. So I did just want to point this out if you think it would be helpful. That said, even though the criteria is very fine-tuned, I would just keep in mind the prior criteria that we were discussing in the last slide. It's possible a case may be flagged as being guidelines eligible when the event itself may not necessarily be guidelines eligible. So just keep all of that in mind when referring to the docket. But hopefully you do find that to be particularly helpful. Now let's discuss how exactly we utilize all of that guidelines data submitted via the sentencing guidelines worksheet to help inform sentencing policy decisions. So generally speaking, the data are assessed to review sentences, and it helps to inform the commission whether changes to individual cell ranges or offense seriousness categories are warranted. The data are also used to monitor compliance and to see how often judges depart for the guidelines for specific offenses and offense types. And then finally, the data are also used to inform the legislature of sentencing patterns for specific offenses or offense categories. So every year we publish an annual report detailing various sentencing trends throughout the state of Maryland. All of our annual reports are accessible via our website. So if that's something that may be of interest to you, please feel free to check out those annual reports on our website. All right, so moving towards guidelines worksheet, I want to discuss the purpose of the sentencing guidelines worksheet itself. Now, the first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. So Criminal Procedure Article 6-216, it indicates that the court shall consider the guidelines at sentencing. And in order to do so, a sentencing guidelines worksheet must be prepared. The second purpose of the worksheet is to provide data so the commission can make informed decisions about sentencing policy. So Criminal Procedure Article 6-210 then requires that the commission collect the sentencing guidelines worksheet, automate that information, and monitor sentencing practice. Okay, so now that we've discussed a little bit about the background and goals of the Sentencing Commission, we're going to start moving forward and reviewing how the guidelines are calculated. And we're going to begin by discussing what constitutes a single criminal event versus multiple criminal events. Now, a single criminal event is defined as one or more crimes committed in the course of the same transaction. Now, additionally, the language noted in red became effective February 1 of this year and states that in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the worksheet shall consider whether the crimes are committed close in time in an uninterrupted course of conduct, occur in the same location, and are similar in nature or intertwined, for example, whether they share a common scheme or purpose. Now, this added language drew on guidance provided by a 2022 Supreme Court opinion, and while it doesn't alter the current guidelines rules, the revisions provide further guidance to practitioners when determining whether multiple crimes are committed during the course of the same transaction. Now, multiple criminal events means that more than one criminal transaction was committed over a period of time. Multiple criminal events being sentenced together, they may have occurred on the same date or different dates. They often also have unique case numbers, but offenses that occur on different dates, they're almost always considered separate criminal events. Now let's discuss what constitutes a sentencing event. Now, a sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. So when you have multiple criminal events sentenced by the same judge on the same day, they still constitute one sentencing event, meaning that one set of sentencing guidelines should be completed for each sentencing event. And we're going to take a look at what that looks like in the next slide. But before we do, I also want to note that any merged or null pros offenses should not be included on the sentencing guidelines worksheet. And once we get into the MAGS demonstration, I'm going to show you how you can delete any offenses that end up being merged or null pros. But just keep in mind, they should not be reflected on the worksheet and should not factor into guidelines calculation. Okay, so let's look at an example to illustrate how one sentencing event may include multiple criminal events. And I know the text is a little small here, so just bear with me. This example shows worksheets for two separate criminal events being sentenced together by the same judge on the same day. So we can see in the upper left-hand corner here, we have a distribution of PCP with an offense date of July 10th of 2021, has its own unique case number ending in 4001. Now, in the bottom right-hand corner, we have an assault first degree that occurred on a different date, that being January 25th of 2022, again, has its own unique case number ending in 8001. Now, by guidelines rule, each separate criminal event should correspond to its own guidelines worksheet. So in this scenario here, even though we have one convicted offense per criminal event, it's still correct for each convicted offense to be reflected on its own separate worksheet. And we can see the individual guidelines range is calculated for each convicted offense. However, there is still one overall guidelines range calculated between them, given that they are a part of the same sentencing event. And when we get into MAGS, I'm going to kind of reiterate and reemphasize this multiple criminal event, single sentencing event scenario. Okay, so moving on, the next section to discuss is the convicted offense information. So pretty self-explanatory. This is where we're capturing the date of the offense as well as convicted offense information. Before we get to that part, I do just want to note these two boxes in the upper left-hand corner. So we can see that this says at this sentencing, the number of convicted offenses and criminal events. So that will reflect the number of convicted offenses and criminal events within the sentencing event. I just want to note, when you're inputting information into MAGS, you want to make sure that you're properly noting, especially the number of criminal events, since that does play a big part and factoring into how the overall guidelines range is calculated. So just keep that in mind when looking at these boxes here on the guidelines worksheet. So jumping down to convicted offense title, pretty self-explanatory. Based on the convicted offense that you select in MAGS, the worksheet will then populate the CJIS code, the statute, the statutory maximum, if there were a mandatory minimum corresponding to the offense, as well as the case number for that particular offense. Now, the last column that I want to point out here, you can see it has the Roman numeral equivalents of 1 through 7. That's the seriousness category column. And I'm going to divert from the worksheet for a second to talk a little bit more about that. Now, most of you are probably somewhat familiar with the general framework, but I just want to give a brief overview of the basic premise of the guidelines. So Maryland has 3 separate sentencing matrices. We have one for property that you see here, one for drug offenses, and one for person offenses. So those typically involving victims such as assault, robbery, as well as weapon-related offenses. Now, the guidelines were designed to take both offender and offense characteristics into account. So looking on the left-hand side here, we can see that this first column represents the offense seriousness category. Each offense in Maryland is ranked based on its seriousness, with 7 being the least serious to 1 being the most serious. And we can see for property offenses, those range from a seriousness category 7 to a seriousness category 2. Now, the top row here, we're going to discuss this in more detail. It's the offender score. It captures components of an offender's prior criminal history. So let's just walk through a basic example. Let's say we have a defendant who was convicted of theft less than 100, which is a seriousness category 7 property offense. Let's say they have no prior criminal records, so an offender score of 0. Looking to this matrix here, we can see that the recommended guidelines range would be probation to probation in that particular case. So again, that's just a basic example of how the guidelines are calculated, and just reiterates how important the offense seriousness category plays in the calculation of the guidelines themselves. So returning to the worksheet calculation process, the next section that we're going to discuss is the offense score section. Now, the offense score only applies to person offenses. So I mentioned earlier, those are typically offenses involving victims like assault, robbery, as well as weapon-related offenses. So the offense score is not calculated for property or drug offenses. The offense score is a summary scale ranging from 1 to 15, and it measures the seriousness of a person offense based on 4 components, that being the seriousness category, victim injury, weapon presence, and special victim vulnerability. Now, the first section here is the offense seriousness score, and it provides a conversion chart shown on the worksheet whereby the least serious offenses, so those being the categories 5 through 7, are assigned 1 point, to the most serious, the category 1s being assigned 10 points. Now, with regards to the offense score in the seriousness category of an offense, I just want to note that in general, any attempt, conspiracy, or solicitation to commit a given offense, it's generally going to be assigned the same seriousness category as the underlying offense. That being said, there are a few exceptions involving some of the more serious offenses. So, for example, attempted first-degree murder is a category 2 offense, whereas first-degree murder is a category 1. The same is true for rape. So if there's ever a question as to the seriousness category for some of those more serious offenses, if they do involve an attempt, conspiracy, etc., just refer to our guidelines offense table. Both the PDF version and the MAGS, the offense table and MAGS, they list all of those offense entries separately. If it does involve an attempt, conspiracy, etc., for one of those more serious offenses. Now, moving on to victim injury. So it's defined in our Maryland Sentencing Guidelines manual as reasonable proof of injury, which may be physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the convicted offense. Now, non-permanent injuries are assigned 1 point, and permanent injuries or death are assigned 2 points. Also, just want to note that psychological injuries shall be based on confirmed medical diagnosis or psychological counseling or treatment. And psychological injuries is presumed not permanent unless otherwise demonstrated. Physical injuries shall also be more than minimal. So I will say this particular component of the offense score, there does tend to be a little bit of gray area. So for example, we've been asked multiple times in this particular scenario, let's say we have a victim who ended up being stabbed in the course of the conduct of the particular defendant in a case. Now, the question has been whether the scar that they sustained, if that would constitute a non-permanent injury or a permanent injury. And the answer is that the instructions in our manual just don't get into that level of detail. So it would ultimately be at the worksheet preparer's discretion as to whether they would consider that a permanent or non-permanent injury. Now, if the defense happened to disagree with how either the state or the parole and probation agent calculated those points, then it should be brought to the judge's attention at sentencing. And ultimately, the judge will decide the proper number of points that should be scored for victim injury in that circumstance. Now, moving on to Part C here, which is weapon presence. Now, weapon presence is defined as the presence of any article or device that reasonably appears capable of causing injury. 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun. 2 points are scored for a firearm or an explosive. Also, just want to note that when calculating the offense score, a judge may include factors known to the judge when making this decision, even if they are not within the scope of the convicted offense. So for example, if you have a defendant who was charged with armed robbery, but they eventually end up pleading to robbery, points may still be awarded for firearm or weapon presence in that particular scenario. Now, before we review a recent update pertaining to weapon presence points, I want to start with a poll question here. So when this poll populates, please select whether you believe gasoline or a lighter would constitute an explosive for the purposes of assigning weapon presence points. I'm going to go ahead and launch this poll here. Just to note, the poll questions, your answers are anonymous. We just use this as a nice exercise. Common questions that we get relating to guidelines, we like to highlight them via poll questions during webinars. So go ahead and make your selection. I'll read the question one more time, and then I'll go ahead and share the results. So, does gasoline or a lighter constitute an explosive as it pertains to weapon presence points? Yes or no? I have just a couple people submitting their answers. I'll give you all a couple more seconds. Okay, so I'm going to go ahead and share the results here. All right, so this is split 50-50. Let's go ahead and take a look at the answer here. And the answer is no. So let's review a recent update that clarifies these instructions here. Now, in response to multiple inquiries asking whether the presence of items designed to start a fire, such as gasoline and a lighter, would constitute an explosive as it pertains to the assignment of weapon presence points, the commission reviewed this issue and decided to clarify the offense score instructions to reference the definitions of explosive and incendiary materials provided in Criminal Law Article 4-501. So the revised instructions, which are the added language that you see bolded here, they indicate that the individual completing the worksheet shall assign a score of 0 if no weapon was present, a score of 1 if a weapon other than a firearm was present, or 2, a score of 2 if a firearm or an explosive material was present. Now, further, the following rules regarding weapons shall apply. First, that explosive material as defined in Criminal Law Article 4-501 is considered the same as a firearm. And second, weapons other than firearms include incendiary and toxic materials as defined in Criminal Law Article 4-501, knives, tire irons, and clubs. So based on this clarifying language, the presence of gasoline and a lighter, perhaps to set a person on fire, etc., would constitute a victim other than a firearm, that being incendiary material, and would be awarded 1 point for weapon presence. And this became adopted and effective November 14th of last year. So I'm glad that we were able to review these recent revised instructions, given that the poll question was split 50-50. So hopefully that helped to provide some clarification. All right, so before we discuss part C of the offender score, I'm going to generate another poll question regarding the circumstances in which an individual qualifies as a vulnerable victim. So let me go ahead and launch this second poll question here. So would a victim who is known by the defendant to be intoxicated meet the criteria for a vulnerable victim? You can go ahead and start making your selections, and I'll read the question one more time. So would a victim who was known by the defendant to be intoxicated meet the criteria for a vulnerable victim? Do you think yes or no? Just give you a couple more seconds here. Okay, I'm going to go ahead and share the results here. Okay, so we have 63% thinking yes and 38% thinking no. So let's go ahead and take a look here. And the answer is yes. But the answer, it's also less clear cut than some of these other poll questions, as the current instructions, they are somewhat subjective. So let's take a look at the factors that are used to determine if a victim is especially vulnerable. Now, 1 point would be scored for special victim vulnerability if the victim is younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who is physically or mentally limited in a material way. Now, examples of a temporary physical or mental limitation include, but are not limited to, instances in when the offender knew or should have known the victim was pregnant, unconscious, asleep, or intoxicated. Okay. So moving on to the offender score section that we see highlighted here in yellow. Now, we talked about this a little bit earlier, but the offender score, it's a summary scale ranging from 0 to 9, which measures an offender's criminal history, taking into account 4 factors. A, the relationship to the criminal justice system when the instant offense occurred. B, juvenile delinquency. C, prior adult criminal record. And D, prior adult parole and probation violations. Now, before we jump into part A here, we're going to have a true or false question. So let me go ahead and launch this poll, and then I'll read the question here. Give me 1 second. Okay, so true or false? 1 point should be scored for part A of the offender score, the relationship to the criminal justice system when the instant offense occurred, if the defendant was on pre-trial supervision at the time the instant offense occurred. Is that true or false? And I'll read it one more time while you all start making selections here. So true or false? 1 point should be scored for part A of the offender score, relationship to the criminal justice system when the instant offense occurred, if the defendant was on pre-trial supervision at the time the instant offense occurred. This is probably the most common question we get regarding part A of the offender score. So I always like to highlight it in a webinar here. I'll give you all about 5 more seconds. Okay, let's go ahead and share the results here. So we have 63% thinking true and 38% think that this is false. So let's go ahead and take a look at the answer here. And the answer is false. So let's take a look at why that is. Now, offenders should receive 1 point if they are in the criminal justice system. For example, if they're on parole, probation, etc., as a result of an adjudication of guilt as an adult at the time the offense was committed. So generally speaking, when someone's on pretrial supervision, they haven't often yet been adjudicated guilty for that particular offense. And that's why normally 1 point would not be scored for being in the criminal justice system at the time of the instant offense. That being said, it is possible for the defendant to be on pretrial supervision. They've been adjudicated guilty, but are still on pretrial supervision pending sentencing. So if the defendant then committed this instant offense after having been adjudicated guilty and pending sentencing, at that point, 1 point could be scored for being in the criminal justice system. But generally, when being on pretrial supervision, they haven't yet been adjudicated guilty, which is why 1 point would not normally be scored for this particular component of the offender score. So hopefully that helps to provide some clarification. Like I mentioned, it's probably one of the most common questions we get regarding part A, which is why I always like to highlight it. Now, moving on to part B, juvenile delinquency. So 0 points are scored here if the offender is 23 years old or older by the date of the most recent instant offense, or if the offender has 0 findings of a delinquent act within 5 years of the date of the most recent instant offense. 1 point is scored if the offender is under 23 and has 2 or more findings of a delinquent act within 5 years of the date of the most recent instant offense, and 2 points scored if the offender is under 23 excuse me, and has had 3 or more findings of a delinquent act within 5 years of the date of the most recent instant offense. Now, a couple more items I want to note with regard to the juvenile delinquency scoring instructions. The first is that only 1 finding of a delinquent act, so that being the finding of facts sustained at an adjudicatory hearing, should be counted for a single adjudicatory hearing, meaning that if you have multiple findings of a delinquent act relating to a single adjudicatory hearing, the individual completing the worksheet shall count only 1 finding of a delinquent act. Also want to note that effective October 1 of 2022, a revision was added to the guidelines manual, providing the additional instruction that the juvenile delinquency record may not include adjudications based on acts that are no longer crimes. So this revision is consistent with the instructions for scoring Part C of the offender score, that being the prior adult criminal record, which also states that the prior adult criminal record shall not include adjudications based on acts that are no longer crimes. So this revision was added for consistency purposes. Now, moving on to Part C, prior adult criminal record. Now, aside from a few exceptions that we have further noted in our manual, the prior adult criminal record generally includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. Now let's launch another poll question here. Now, true or false, only 1 adjudication per criminal transaction should be counted towards the prior record score. Go ahead and launch this poll question here. True or false, only 1 adjudication per prior criminal transaction should be counted towards the prior record score. You can go ahead and make your selection. I'll give you a couple seconds. And then we'll take a look. Okay, so let's go ahead. I'm going to share the results here. So 63% thinking true and 38% thinking false. So let's go ahead and take a look at the answer here. And the answer is true. So this is similar to those instructions that I was just discussing as they pertain to the juvenile delinquency scoring. Let's take a closer look at breaking down how the prior adult criminal record is calculated. This is probably the most complicated component of the offender score, so I'm going to break it down and discuss it in further detail, and then we're going to apply it to a hypothetical scenario. Now, the first step in calculating the prior record is to identify the offense with the highest seriousness category for each prior criminal transaction. So if you have multiple adjudications that stem from the same criminal transaction, you're only going to want to count the offense with the highest seriousness category among those adjudications. Step 2 is then to count the number of offenses in each seriousness category using only the offenses that you identified in step 1. Step 3 is then to refer to our criminal record matrix to identify the corresponding prior record level. Before we take a look at that, I do also want to note that Maryland allows for what we refer to as a criminal record decay factor, meaning that if the defendant has remained free of criminal justice system involvement, so meaning they have been off parole, probation, mandatory supervision, etc., if they have remained free of that involvement for 10 years prior to the instant offense, the criminal record should be reduced by 1 level, meaning that if the prior record's initially calculated to be a moderate, as long as the defendant's prior record meets this criteria for the criminal record decay factor, it would then be reduced from a moderate to a minor record level. So here's a screenshot of our prior adult criminal record matrix, and let's walk through a hypothetical scenario. So let's say we have a defendant with the following prior record. Let's say on October 1st of 2013, this particular defendant was convicted of assault second degree, which is a category 5, and a wear, carry, transport of a handgun, which is a seriousness category 7, both person offenses. Now, since I have multiple convictions that stem from the same transaction, I'm only going to count the most serious offense, that being the assault second degree, which is a category 5. Then on July 28th of 2016, the defendant was convicted of burglary second degree, which is a category 4. And then on December 12th of 2020, the defendant was convicted of destruction of property less than 1,000, which is a seriousness category 7. Now, looking at all of these adjudications, so that being the assault second degree, the burglary second degree, and the destruction of property, I can see that the most serious is the burglary second degree, which is a category 4. So looking to this prior adult criminal record matrix, I have the seriousness category column on the left-hand side with the number of convictions per seriousness category is the top row here. So I can see I have one seriousness category 4 conviction, meaning I'm going to look to this first box here. And we can see initially this prior record is calculated to be a moderate, but would jump to a major if combined with 2 or more offenses in categories 4 through 6, or any 6 offenses in general. So since the rest of the criminal history doesn't meet the criteria for a major, this would result in a moderate record level. So hopefully that helped walking through a sample scenario. Like I mentioned before, we know that this is probably the most complicated component of the offender score. If you ever have questions about calculating it, just feel free to reach out to our staff. We're always happy to help. Now, wrapping up the offender score with Part D, prior adult parole and probation violations. 1 point is scored if the offender was ever adjudicated in violation of parole and probation, or was convicted of an offense while on parole or probation, unless the adjudication or conviction arose from the offense or offenses of this sentencing event. So that wraps up the offender score. Let's take a look at this section that we see highlighted in here, which captures the recommended guidelines ranges. So I mentioned earlier, when viewing the worksheet, you'll see that there's space for the individual guidelines range for each convicted offense, and then the overall guidelines range is calculated and displayed towards the bottom of the worksheet here. So let's take a look at a couple of examples that illustrate how the guidelines range is adjusted due to special circumstances in a case. Now we're going to start here with an example of utilizing the multiple victim stacking rule. So here's an example of where the overall guidelines range is adjusted due to a case involving multiple victims within a criminal event and not more than one seriousness category 1 or 2 offense. So in this type of case, the guidelines range for each individual offense is still calculated as normal. But instead of using the highest of the upper and lower guidelines limit, it's the highest of the lower limit that's taken, and then the upper limits for each offense involving a unique victim are instead added or stacked. And just to note, if you have multiple offenses that relate to the same victim, you would only stack the upper limit for the most serious offense. So in this example here, we have a defendant who was charged with 3 counts of second-degree assault with 3 separate victims, each count originating out of the same criminal event. So we can see that the multiple victim stacking rule was applied for each of these offenses, given that they involve 3 separate victims. Now, the overall range from this offense was adjusted to account for the 3 separate victims. So we can see that it increased from 2 years to 5 years to 2 years to 15 years. Again, to reflect that 3 separate victims were involved in the case, with those upper limits per offense being added to obtain that 15-year upper limit. So let's recap the rules regarding when the stacking rule can be applied. So just to reiterate, there must be a criminal event involving multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense within that criminal event, and only one convicted offense per distinct victim may be used to calculate the overall guidelines. And finally, that only the upper limits stack. Now let's launch another poll question here. This again is a very common question that we receive. So true or false, the stacking rule can only apply towards person offenses. Let me go ahead and launch this poll here. So do you think that's true or false? The stacking rule can only apply towards person offenses. Give you a couple seconds here. All right, looks like we have the majority locked in. Let's share the results here. So this is 50-50. Again, this is why I love bringing this question up during webinars. So let's go ahead and take a look at the answer here. So the answer is false. So just to reiterate, the stacking rule, it can also be applied towards property offenses as well. So for example, if you have multiple victims of a theft or fraud related case, if it stems from the same criminal transaction involving multiple victims, you can certainly apply the stacking rule in that instance as well. It is not limited to person offenses. So just wanted to highlight that again. Okay, so another instance where the overall guidelines range is adjusted is the subsequent offender sentence enhancement. So in this example illustrated here, we show a case where the offender was convicted as a subsequent drug offender pursuant to criminal law article 5-905. So in this example, the offender was sentenced to distribution of cocaine, had a hypothetical offender score of 3. So in this case, the guidelines range is initially calculated to be 3 months to 3 years. However, because this offender was convicted as a subsequent drug offender pursuant to criminal law 5-905, under that statute, the statutory maximum is then doubled from 20 to 40 years. And by guidelines rule, the guidelines range is then also doubled, which is why it increases to 6 months to 6 years in this particular scenario. So just wanted to highlight that special circumstance as well. Okay, so wrapping up with the sections of the worksheet, the next section we see highlighted here, it's the victim information section. These questions pertain to the rights of victims at sentencing. State Board of Victim Services has asked us to collect this information on their behalf. So we do ask and encourage state's attorneys and parole and probation agents to enter as much information pertaining to the victim information section as possible. And then wrapping up the remaining fields that you see highlighted here, these are the sentencing and departure related fields that are typically completed by judges or his or her designee post-sentencing. So that can include the individual sentence information for each convicted offense, use of corrections options, whether victim court costs were imposed, etc. So before we get into the MAGS demonstration, I want to also recap how to determine if a sentence is guidelines compliant. Now, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, if it falls within the applicable guidelines range. So please note that generally suspended time is not considered when determining whether a sentence is compliant. There's one exception involving corrections options, which we'll talk about in a moment here, but generally suspended time is not considered. Also, just want to note that compliance is calculated by comparing the overall sentence across all convicted offenses in a sentencing event to the overall guidelines range for the sentencing event. So, for example, it's possible that the sentence could exceed the upper guidelines limit for one offense in a sentencing event, fall below the lower guidelines limit for a second offense, but the overall sentence, when adding together the sentence for both counts and taking into consideration whether those are running concurrently or consecutively to one another, it could fall within the overall guidelines range for the sentencing event. Now, there are a few qualifiers to consider regarding guidelines compliance. The first is that effective April 1 of 2021, sentences adjudicated pursuant to an MSCCSP binding plea agreement are deemed guidelines compliant. Some of you might remember the former ABA plea agreement that was utilized several years ago. But it's important to note that that former ABA plea agreement disposition type, it has now been replaced with MSCCSP binding plea agreement. And the criteria for what constitutes a guidelines compliant MSCCSP binding plea agreement, it has also been revised. We're going to look at that in a moment, but just also want to note that this MSCCSP binding plea compliance rule, it does follow the same logic as the former ABA plea agreement compliance rule, which was initiated based on feedback received from the judiciary that binding pleas represent a consensus of the parties and the court within their specific community. And accordingly, the commission felt it was important to define these as compliant sentences. Now, binding pleas are three-party agreements in which the state and the defense present to the court on the record an agreement that incorporates a specific sentence. And if the judge accepts that agreement, it becomes binding on the court pursuant to Maryland Rule 4-243, subsection C. Now, following a review of binding pleas in 2020, the commission ultimately agreed that the former term ABA plea agreement was not universally known and should be replaced with the more intuitive MSCCSP binding plea agreement. And further, effective April 1 of 2021, the MSCCSP narrowed the definition of what constitutes a guidelines compliant plea and adopted language that specifies the following. An MSCCSP binding plea agreement is a plea agreement presented to the court in agreement by an attorney for the government and the defendant's attorney, or the defendant when proceeding pro se, that the court has approved relating to a particular sentence and disposition. An MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, and not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and the agreement is binding on the court under Maryland Rule 4-243, subsection C, if the court accepts the plea. Now, I know that was a lot to read and digest, so let's incorporate that and look at another poll question here. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Now, is this considered an MSCCSP binding plea agreement? I'm going to go ahead and launch the poll. I did have to abbreviate it a bit in poll questions, so let me just read the slide one more time here. So if we say the guidelines for the sentencing event are 2 years to 8 years, the state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Would this be considered an MSCCSP binding plea agreement? Give you all a couple more seconds here. All right, looks like we have majority made their selection. All right, so 75% think that yes, this is an MSCCSP binding plea, 25% think no. So let's go ahead and take a look at the answer here. And the answer is no. So this would not constitute an MSCCSP binding plea. So just to recap and as a reminder, an MSCCSP binding plea, it must involve an agreement to a specific amount of active time, if any, and not merely a sentence range or cap. So in this scenario, the court accepted a plea agreement to a sentence range, anywhere from probation to 2 years. And that is why it would not constitute an MSCCSP binding plea agreement. Okay, so let's take a look at another scenario here. Let's say the guidelines for this sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended, with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended, with credit for 62 days. Is this an MSCCSP binding plea agreement? So let me go ahead and launch this poll. I'll read this scenario one more time. The guidelines for this event are 1 year to 6 years. State and the defense present to the court a plea agreement to 5 years, all suspended, with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended, with credit for 62 days. Is this an MSCCSP binding plea agreement? All right, I'm going to go ahead and share the results here. All right, so 75% think that this is an MSCCSP binding plea, with 25% thinking no. So let's go ahead and take a look at the answer here. So yes, this would constitute an MSCCSP binding plea agreement, because in this scenario, there was an agreement to a specific amount of active time, that being 0, or in other words, no post-sentence incarceration, since the defendant received 5 years, all suspended, with credit for the 62 days. So therefore, this would constitute an MSCCSP binding plea agreement. There's one last scenario I want to cover. This isn't a poll question, but again, I just want to reiterate this particular scenario. So let's say the guidelines for this sentencing event are 1 year to 5 years. State and the defense present to the court a plea agreement to a sentence range anywhere from 2 years to 4 years. The court accepts this agreement and imposes a sentence of 5 years, suspend all but 2 years. So while this agreement is not an MSCCSP binding plea agreement, right, because it contains a sentence, the plea agreement was to a sentence range anywhere from 2 years to 4 years. So it wouldn't constitute an MSCCSP binding plea agreement, but the sentence itself is guidelines compliant. Since the guidelines applicable sentence of 2 years, remember the sum of incarceration, credited time, and home detention time. So that 2 years is falling within the overall guidelines range of 1 year to 5 years. So I just wanted to highlight that scenario to reiterate that it's still possible, obviously, to have a guidelines compliant sentence, even if it is not adjudicated via an MSCCSP binding plea. So again, I know that was probably a lot to take in and digest, but hopefully running through those different scenarios did help to provide some clarification. And again, if you ever have a question, you can feel free to reach out to our staff. So an additional qualifier to consider regarding guidelines compliance is the role of corrections options. Now, sentences to corrections options programs, so that being drug court, residential substance abuse treatment, they are deemed compliant provided that the initial sentence plus any suspended sentence. So essentially, its total sentence is falling within or above the applicable guidelines range, and the case does not include a crime of violence, child sex abuse, or escape. Now, this is the exception that I mentioned earlier, in which suspended time is considered when determining guidelines compliance. So let's take a look at the various corrections options programs. So corrections options, they really allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. And they include home detention, inpatient or residential treatment, inpatient drug or alcohol counseling under Health General 8-505 or 8-507 order, drug court, problem-solving court, required substance abuse treatment for the possession, administration, obtainment, etc. of controlled dangerous substances, work release, weekend, or other discontinuous incarceration. And then wrapping up, guidelines compliance sentences. So the last rule I want to discuss is credit for time served. So if the offender received credit for time served with no post-sentence incarceration time and the amount of credited time exceeds the guidelines range, it is deemed compliant. So for example, if the guidelines range is probation to 3 months and the sentence is 6 months fully suspended with credit for 100 days, the sentence is still considered guidelines compliant, even though the credited time exceeds the upper guidelines limit. Okay, so hopefully that was helpful, just running through those various guidelines compliance scenarios. Before I get into the MAGS demonstration, I do just want to point out our, excuse me, our guidelines calculator tool. Now, our guidelines calculator tool can be accessed from our website right here. And the guidelines calculator tool is a standalone tool that can be utilized by anyone to calculate sample guidelines. So you don't need a user ID, you don't need a password. The only caveat is that it doesn't save any information when you're using the tool. You'll either have to save the PDF that you're working on or print it out. And the guidelines calculator tool, we can see here based on the screenshot, it essentially mirrors MAGS. So these first 3 tabs that you see here, that being offender information, offender score, list of offenses, mirrors those particular MAGS in MAGS as well. And these 3 fields are the ones that are completed prior to sentencing to calculate sentencing guidelines. So I wanted to point this tool out because I know it's particularly helpful. We've gotten a lot of positive feedback, particularly from defense attorneys. They will often utilize this tool to calculate their sample guidelines. Since while you all do have read-only access to worksheets initiated in MAGS, defense attorneys do not have the ability to officially initiate a worksheet in the MAGS system. That's really just to avoid an issue of duplication. If we had multiple parties that were able to officially initiate worksheets in the system, if there were discrepancies, it gets very confusing for judges and their designees to know which one is correct and which worksheet to ultimately submit. So that said, we encourage defense attorneys to access MAGS. You have the state or parole and probation calculated their guidelines. If they disagree, you can certainly utilize this guidelines calculator tool, print out your own PDF of the guidelines worksheet, and bring any discrepancies to the judge at sentencing. And if the judge decides that changes do need to be made to the official worksheet, the state or judge or his or her designee can make those changes in MAGS after the fact. So before I get into the MAGS demonstration, we may have a couple of defense attorneys who joined us this afternoon. And I hope that you all will stick around because, as I just mentioned, the guidelines calculator tool mirrors what you're going to see me do in MAGS, that being initiate a guidelines worksheet. So please stick around so that you can benefit from seeing this demonstration as well. So before logging in, just want to quickly highlight our MAGS homepage here. So www.msccsp.org/MAGS. We have various instructional and support materials. We have a MAGS user manual, very detailed and thorough. We also have 2 MAGS instructional videos. The first is geared towards state's attorneys and parole and probation agents. It's basically going to be showing you what my demonstration is today, which is initiating a sample sentencing guidelines worksheet in MAGS. The second video is geared towards judges and their designees, and will focus on entering sentence information and submitting worksheets in MAGS. So if you ever need a refresher, if you have a new colleague who comes on board, feel free to direct them to our MAGS homepage here. All right, so at this point in time, I'm going to go ahead and bring up MAGS. Just bear with me a second here while I up. Okay, so we should be seeing the MAGS login screen at this point. I'm just going to start by entering user ID. So just to note, everyone's user ID corresponds to their individual agency or jurisdiction. If you have any questions about your user ID, if you haven't yet accessed MAGS, just feel free to reach out to us and I will confirm what your proper user ID, what those credentials should contain. So I'm just going to go ahead and start by entering my credentials and my password here. Okay, so after logging in, you're going to be brought to our home screen here. And from the home screen, you can either create a new worksheet or you can view, edit, or delete an existing one. If you are searching for a previously initiated worksheet, there are a couple of different ways you can search. You can filter entirely by jurisdiction, the defendant state identification number, the first name, last name, case number for the defendant, or the worksheet ID number. Now, the worksheet ID number, I mentioned earlier how when you have multiple criminal events, if they're being sentenced as part of the same sentencing event, how one set of sentencing guidelines should be completed for that event. Now, when you're initiating those worksheets in MAGS, you want to make sure that all of those criminal events are linked and entered under one MAGS record. So I'm just going to go ahead and search for a defendant so we can see what that should look like if initiated properly. Let's say I'm searching the system for a defendant of Jane Johnson here. So once I click search, you can see I have 2 case numbers, 2 unique case numbers, one ending in the 1122 and then one ending in 1133. And if I look to this worksheet ID field, I can see that they're linked with the same worksheet ID number of 118787. So again, if you're initiating guidelines for a sentencing event involving multiple criminal events, you're only going to want to click this add new button one time. And then when you go to enter the convicted offense information on the list of offenses tab, that's where you can reflect the different criminal events as well as those unique case numbers. In the case that I'm going to be initiating today, it is going to be a multiple criminal event, single sentencing event scenario. So we're going to take a look at how to do that properly. Throughout MAGS, you'll see these question mark icons. If you click on the icon, it does give you more detailed explanations of what we're trying to capture within certain fields. All of the information is taken directly from our manual. So if you ever have a question about what we're capturing for a field, please utilize these information icons. The last thing I want to note is that you want to get in the habit of searching the system prior to initiating a brand new worksheet. Particularly with state's attorneys and parole and probation investigators, because it's possible that the state's attorney may have already initiated a worksheet for a particular defendant before knowing that a pre-sentence investigation was going to be ordered. Now, if a PSI is ordered, it is parole and probation's responsibility to initiate the guidelines worksheet. So when logging into MAGS, if you search the system, see that perhaps the state's attorney already initiated a guidelines worksheet for that particular case, take a look at the calculation. If you agree with it, there are some parole and probation agents who, print out the worksheet, attach it to the PSI and leave it at that. I know that some like to write their names since they're officially responsible for initiating that worksheet. Just give the state's attorney a heads up that that's what you intend to do. Now, if you view the state's calculation and don't agree with how a component was calculated, then we do ask that you reach out to the state's attorney and discuss any discrepancy in hopes of reaching a consensus. And then you can just go ahead and make any change necessary to the already initiated worksheet. We're really trying to avoid duplicate worksheets in the system because, as I mentioned earlier, it gets confusing for judges and designees to know which one is correct before submitting the worksheet. So again, making an effort to avoid those duplicate worksheets. Okay, so now that I've gone through that, I'm going to go ahead and click this Add New button because we're going to walk through creating a brand new worksheet here. Once I do that, you're always going to be given this alert message, which is asking you prior to adding the worksheet to please utilize the search feature to confirm that a worksheet has not already been initiated, and only one worksheet should be created for multiple event or offense cases that are sentenced on the same judge by the same day. So I'm going to go ahead and click OK. Now, whether you're editing a new worksheet, initiating a brand new worksheet, you're always going to be brought to the offender information tab first. So you can see we have MAGS. Various tabs are divided into 7 different tabs, each representing a section of the sentencing guidelines worksheet. So, excuse me. Now, offender information, offender score, list of offenses, and most of victim information, those are completed by state's attorneys or parole and probation agents prior to sentencing. And then the judge or his or her designee will take over and enter the remaining sentence fields. In most jurisdictions, that is how it operates. So beginning with offender information, pretty self-explanatory. This is where we're capturing basic information about the worksheet preparer as well as the defendant. So I'm just going to go start by entering information in these fields. Just to note, throughout MAGS, you'll see these red asterisks. So that indicates that it is a mandatory field, meaning that some sort of value has to be entered before ultimately moving on to the next tab. So here I'm entering my defendant's name, state identification number, the sex, the date of birth, whether a pre-sentence investigation was ordered, the jurisdiction, representation, I'm going to select public defender, no ethnicity. And then with regards to race, I do want to note that we allow for multiracial responses. So you can check more than one box there. Once completed, you can click Save this page before moving on to the next tab here. So next tab is offender score section. So this is where we're entering scores for all of those components of the offender score that we discussed earlier. Now, I do just want to note that Part A, relationship to the criminal justice system when the incident offense occurred, that is scored at the offense level. Since you can have multiple criminal events sentenced as part of one sentencing event, sometimes those criminal events can span quite a period of time. One may have occurred even like a year prior to the second criminal event. So it's possible the defendant was on some type of criminal justice supervision when one of those offenses were committed, but not the other. So that is why Part A of the offender score is scored at the offense level. So you would just make selections for juvenile delinquency, prior adult criminal record, and then prior adult parole and probation violations. So just to note here, prior adult criminal record, it is a clickable link. If you click on it, it brings you to our prior record matrix that we looked at earlier. And finally, just want to note, if you need to apply the criminal record decay factor that we talked, excuse me, that we discussed earlier. So let's say in this example, looking at the defendant's prior criminal record, the defendant was initially calculated to have a major prior adult criminal record, but they meet that criteria for the record decay factor. So if I want to apply that, I'm going to select yes here, and you can see that that jumps from a major to a moderate. And then when we view the worksheet, you're going to see the words decay factor populate on the worksheet to show that that has been utilized. So I'm going to click save this page here, and then jumping to the list of offenses tab. So this is where you're going to be entering all of the convicted offense information for the sentencing event. Even if it involves multiple criminal events, all of that is going to be noted on this particular tab. So I mentioned I'm going to initiate a worksheet for 2 criminal events that are a part of the same sentencing event. So to start, I'm just going to click the add offense button here, which brings me to my offense offender score screen. In the upper left-hand corner, I just want to make sure that I'm beginning by noting the proper criminal event. So since this is the first offense here, I'm going to enter this as part of criminal event number 1. Now the count number, you want it to correspond to the count number that's associated with the convicted offense on the indictment. So in this case, let's just say this is count 2. And then the offense date, I'm going to enter this as 11/01 of 2022. Case number, you can see that it pre-populates. Most case numbers are now populating in MDEC format based on the jurisdiction that you select on that first tab here. So I'm just going to go ahead and enter the remaining case number. Also, just to note, no dashes when entering in the MDEC format. Now, convicted offense title, there are 2 different ways you can search. If you click the most common offenses button, this brings you to the 25 most common guidelines eligible offenses, or you can just click the general search button here, which brings you to our entire offense table. Now, within the offense table, there are a couple of different ways you can search. You can search by offense title, the CGIS code, the statute, or the type. So whether it's person, property, or drug. One thing I want to note with regards to the statute, if the penalty for a particular offense is contained in a different statute than that of the offense description, our guidelines offense table will display the penalty portion of the statute. So for example, this comes into play, we get this question a lot with drug-related offenses, where the offense description may be contained in 5-602 of the criminal law article, but the penalty may be contained in 5-608 of the criminal law article. So if I'm having trouble locating a distribution offense, by entering the 5-602 and I can't find it, it's because our offense table contains that penalty portion, that being the 5-608. So just keep that in mind when searching by statute. And with that said, CGIS code, that's always a good go-to to help locate a particular offense fast. Or you can, in the upper left-hand corner here in the search field, you can simultaneously search all of those columns. In this particular case, I'm going to look for an assault second degree. So I'm just going to start by entering the term assault. And you can see once I do that, every offense that contains the word assault is going to populate here. I can see jumping down, I see assault second degree, so I'm going to click select here. Once I do that, MAGS populates the seriousness category, the CGIS code, the statute, stat max. If there were a mandatory minimum, that would populate here. Now, I mentioned earlier, any attempt, conspiracy, or solicitation, it's going to be assigned the same seriousness category as the underlying offense. So generally, you would just be selecting the underlying offense and then selecting the appropriate radio button here. Now, the exception to that rule, as we discussed, involves some of those more serious offenses. For example, attempted first-degree murder versus general first-degree murder. So I just want to show you real quick, if I go back to the offense table and type in murder, you can see how those attempts, conspiracy, solicitation for murder, how those have separate offense entries. And if I were to select this offense entry for attempted first-degree murder, this radio button would then be grayed out. It wouldn't allow me to do that. So just keep that in mind, especially when you're calculating guidelines for some of those more serious offenses. Now jumping down to enhancements here, I'm just going to click this drop down. If the underlying offense allowed for any of the following enhancements, so whether you're applying the subsequent drug offense and by guidelines rule, the range doubling enhancement, you could apply that here. If the defendant's being convicted for a subsequent crime of violence and therefore subject to the 10, 25, or life mandatory minimum, or if they're a repeat sex offender and being charged with the life maximum, you could apply those enhancements here. Finally, if you want to flag an offense for the multiple victim stacking rule, you would just do so by selecting the radio button, yes. MAGS is going to remind you that the stacking rule can only be applied when there's a criminal event with multiple unique victims and not more than one seriousness category 1 or 2 offense. And in order for the upper guidelines limits to stack, that the flag must be applied to at least 2 offenses within a criminal event, each with a unique victim. So the scenario that I'm entering into MAGS today, it's not going to meet this criteria, so I'm going to switch that to no. But if you want to utilize a stacking rule, that's where you would flag an offense. So jumping down to the offender score, I mentioned part A is scored at the offense level. So I would just mark whether the defendant was under criminal justice system supervision when this incident offense occurred. So I'm going to go ahead and mark none. And you can see the selections I made on the offender information tab for juvenile delinquency, prior adult criminal record, and prior adult parole and probation violations. Those pre-populate and MAGS calculates the total offender score for you. Now on the right-hand side here, we talked about the offense score and how this only applies towards person offenses. Assault second degree, it is a person offense, so I'm going to be prompted to enter selections for a victim injury. So let's say it's an injury non-permanent with no weapon presence, and the defendant doesn't, or sorry, the victim does not meet the criteria for special victim vulnerability. So similarly, the offense score would automatically populate based on your selections there. You then jump down and you want to click calculate guidelines range. MAGS would then calculate the individual guidelines range for the offense, as well as the overall guidelines range for the sentencing event. So I am then going to click save this page and close. Okay, so I know we're at 1:15. If we can, I have about probably 15 more minutes. If you're able to hang on until 1:30, just so we can finish up this MAGS demonstration, that would be great. So I'm going to go ahead now. I see my assault first degree corresponding to criminal event number 1 with the case number 1122. Now I'm going to go ahead and add another offense. So this is going to be a burglary first degree that occurred on a different date. So it's going to have a different unique case number. Therefore, I'm going to make this criminal event number 2. So this is going to be criminal event number 2, and it's going to be count 1 within criminal event number 2. So it's going to have a different offense date than the one that I just entered and a different case number. 1144 here. So I can just click most common offenses here, and I'm going to select burglary first degree. Now jumping down, I'm not applying any sort of enhancement. So jumping down to offender score, I still need to make the selection for part A. And you can see the offense score, since burglary first degree is a property offense, I'm not being prompted to enter the offense score, since the offense score does not apply towards burglary offenses. So all I have to do is just jump down to the calculate guidelines range. Now, we talked earlier about how the commission made changes to many of the individual cell ranges for drug and property matrices back on July 1 of 2022. So this alert message does appear. Stating that effective July 1 of 2022, that the guidelines for this offense seriousness category and offender score have changed. And it's just asking you to confirm whether the sentence date takes place on or after July 1, just so the proper sentencing guidelines are utilized in the case. So I'm going to confirm yes. And you can see then MAGS calculates the guidelines to be 3 months to 3 years for the burglary. And then the overall guidelines range increases to 6 months to 5 years. So I'm going to click save this page and close. So there I have my unique case number information, and I can see that I have 2 criminal events total thus far. So I'm going to quickly add one more offense here. So this is going to be a felony theft offense that occurred as part of criminal event number 2. So it occurred at the same time of the burglary first degree here. So I want this to be a part of criminal event number 2. But it's going to be count 4. So a different count number than the burglary that I just entered here. So it's going to have the same offense date as what I just entered, as well as the same case number here. I'm going to click most common offenses. And like I said, I want to search for a theft. And it's this felony theft or theft scheme 1,500, but less than 25,000 is what I'm trying to locate. So I'm going to click select. I'm going to jump down to relationship to the CJS when the instant offense occurred, and calculate guidelines range, confirming it's being sentenced after July 1. And there I have my guidelines for this offense as probation to 1 year, with the overall guidelines as 6 months to 5 years for the sentencing event. Oh, no. I don't know why that was not. Sorry about that. Give me 1 second. Not sure why that take. I can do this real quick. Oh, it just took a minute. Okay, so now I have 2 felony thefts. That's fine. So you can see here, I have my 2 criminal events with all of the convicted offenses between them here. Now, the last tab that state's attorneys and parole and probation are generally responsible for completing is this victim information tab. Again, you can utilize these information icons that explain what we're capturing for each particular question here. If there's no victim in the case, you could just select no, and you'll see that all of these fields pre-populate with no. If there is a victim, we do ask you to make selections to as many of these fields as possible. Now, that said, it is some of these fields, for example, whether the victim was present at sentencing, if they gave a written or oral victim impact statement, those are typically answered by judges or their designees post-sentencing. But again, the majority of these fields, we do ask that you complete pre-sentencing here. So at this point, all of the information has been entered that should be entered pre-sentencing. So if I want to view my worksheet at this point, I'm just going to click the View Worksheet PDF button in the lower left-hand corner. And you can see once I do that, I noted earlier how separate criminal events, how they should correspond to their own worksheet. So since I have 2 criminal events total, you can see it begins with the assault first degree on this first page. And then if I scroll, I can see all of the convicted information for that second criminal event populating on the second page here. So then you can save the PDF to your computer, print it out and bring it to court, whatever your normal practice is. So I mentioned earlier, merged or null pros offenses, how those should be removed from guidelines calculation. So if you are initially calculating guidelines and initiating a worksheet, but after the fact find out that some of the offenses are going to end up being merged or null pros, you do want to remove them from the guidelines worksheet. So to do that, you would just click on this list of offenses tab. And let's say this felony theft offense that we entered, let's say that ends up being merged at sentencing. So I'm going to go ahead and click delete offense next to that particular offense and confirm I want to delete it. Same with this one here. Now, since it tends to be the lesser offenses that end up being merged or null pros, so it doesn't normally affect guidelines, the overall guidelines range calculation when you do delete them. But if it did happen to affect the guidelines range calculation, MAGS would automatically update this guidelines range for you once those are deleted. And then you would click save this page here. Okay, so that wraps up the MAGS demonstration. We just have a couple more slides to get through, and we should be done hopefully right around 1:30 here. So just give me 1 second to pull up the PowerPoint. Okay, so before we conclude, I just want to quickly highlight some recent and forthcoming updates to the sentencing guidelines. I know we already went through a couple of them, but I do just want to note that effective January 1 of 2023, the maximum penalty for violations of criminal law 5-602B1 and 603B, that being unlawfully possessing with intent to distribute, manufacture, possess production equipment of cannabis, the maximum penalty has decreased from 5 years to 3 years. And accordingly, the commission voted to change the seriousness category for this particular offense from 4 to 5. Now, this proposed revision, it was submitted to the Code of Maryland regulations in December 2022 for promulgation through the review process, and it has an expected implementation date of April 1 of 2023, at which time the corresponding offense entry for violations of criminal law 5-602B1 and 5-603B in MAGS will be revised. So just to note, in the meantime, the current sentencing guidelines do not conflict with the new statutory maximum. as none of the ranges for the current seriousness category for a drug offense currently exceeds 3 years. So also to note that these cannabis penalty changes, they will also impact the prior adult criminal record calculation, which is Part C of the offender score. So specifically, per guidelines rule, adjudications based on acts that are no longer crimes should be excluded from the prior adult criminal record. And pursuant to Criminal Law Article 5-601 C2I, possession of more than 2.5 ounces of cannabis is still punishable by up to 6 months of incarceration. However, effective January 1 of 2023, possession of 2.5 ounces or less of cannabis has been decriminalized. So if it can be determined that a prior adjudication for possession of cannabis involved 2.5 ounces or less, it should be excluded from the calculation of the prior adult criminal record. If you are not able to determine the amount that was involved, we do recommend that you count it towards the prior adult criminal record. And then if either state or the defense comes into knowledge that the case did actually end up involving 2.5 ounces or less, that can be brought to the judge's attention at sentencing, and it can be excluded from the prior adult criminal record score. Lastly, I just want to note that as required by the enactment of Chapter 141, Acts of 2022, the Commission is pleased to announce the deployment of its Crimes of Violence Data Dashboard. So here's a screenshot that you see here. So this dashboard, it provides key characteristics for guidelines eligible crimes of violence that were sentenced in Maryland circuit courts in fiscal year 2022. And a summary of these figures are also provided in our 2022 annual report. So this dashboard, it can be accessed from our website and at the link that you see displayed here. And like I mentioned, here's a screenshot of the dashboard. There's various tabs that you can filter through. All right, so I'm going to wrap up by highlighting just a few of our Commission resources. So I just want to note that our website itself is continually updated throughout the year. It's a really useful resource for any of those individuals who implement the sentencing guidelines. It includes the annual reports that I discussed. We also have all of our guidelines e-news available and accessible from our website. The guidelines e-news, it helps to inform about changes to the guidelines. If you don't currently subscribe to our listserv but you would like to be added, please send us an email to our general account and I'll be happy to add you to our listserv so that you do receive them. More recently, we've also started producing a series of topical mini reports that we title Sentencing Snapshots that are intended to provide a quick review of some sentencing trends and other topics of interest. So our most recent sentencing snapshot, it provided a closer look at sentencing trends in Maryland circuit courts for murder. So all of these issues of our sentencing snapshots are available on our website. If you subscribe to our listserv, you'll also receive these via email. My colleague, Sarah Bold, she takes the lead on compiling these sentencing snapshots. She does a fantastic job and we've gotten a lot of positive feedback in response to them. So again, if you're interested, access them through our website or you can ask to be added to our listserv to receive future issues. So the website also provides access to our PDFs of our guidelines manual and guidelines offense table, as well as access to MAGS and the guidelines calculator tool. We have various instructional videos as well as guidelines training webinar recordings. So here's a screenshot of our training page here. You can see all of those videos listed under resources. Any upcoming webinar trainings are also displayed on the training page here, and you can feel free to register directly through that training page. We also have a YouTube channel. So if you just go to YouTube and type in MSCCSP, you'll see all of our various videos displayed on our YouTube channel. Also accessible from our website is that Crimes of Violence Data Dashboard that I just mentioned. So if that's something that may be of interest to you, please check that out. And finally, if you ever have to reach us over the phone, our help desk at 301-403-4165 or via email at msccsp@umd.edu. We're always happy to help. If you've ever reached out with a guidelines or MAGS related question, we've probably spoken at some point. I'm the first point of contact for the Commission. So again, if you ever have a question, please do not hesitate to reach out to us. And that concludes the webinar at this point. I just want to check in with Sarah real quick to see if there's anything outstanding that we need to address before we conclude.
Hi, Catherine. No, we don't have any outstanding questions. We did have a number of participants ask about logging into MAGS, login information, and just so for anybody who needs assistance with that process, you can just email us at our email account, which is listed on the bottom of this slide here, msccsp@umd.edu.
Perfect. Thank you, Sarah. All right, well, that concludes today's webinar. Again, thank you so much for taking time out of your day to attend the training. I know we covered a ton of material, but I hope you found it informative and helpful. And again, feel free to reach out to us with any questions. So thank you all and have a great rest of your day.